So we are going to speak for a good chunk of time on successfully managing disabilities in the workplace. I'm going to turn it over to my colleagues Kathleen and Alex, who are going to take us through the next part of the program.
Hi everyone, I'm Kathleen Chevalier. I'm a partner in the Labor and Employment Group here in Toronto, and my colleague, who will say hi to you in a minute, is Alex. He's also an associate in our group. So, okay. You've had a lot of information thrown at you already. You've been sitting for a long time. I've had a lot of coffee, as I've been sitting there as well. So we're in the home stretch now. We're in this together. This is going to be an interesting presentation. I can't guarantee it, but I hope it will be for you. And you'll notice that it's called Successfully Managing Disabilities in the Workplace. Legal disclaimer, we cannot guarantee success, but we are going to set you up for it today. That is our goal. So I am sure most, if not all, of the employers in this room have had to deal with accommodation measures in the workplace for various types of issues. But one of the issues that's becoming more and more common that we're seeing from our clients is managing disability. And so I should say, prior to getting into it, this is what you will want to have in front of you as we go through the latter half of our presentation. There's a folder, should be at everyone's place. And in it is a fact scenario called case study, this document right here. And what we call our lovely little decision tree, or skeleton, you'll hear it referred to as that, to guide you through the fact scenario. I would like to say that you have seen other models like this. This was our idea. Everyone copied it. We are the original creators. So with that taken care of, we will also have questions at the end. So I know this is a very contextual topic, and we're going to do our very best through the case study and the decision tree or skeleton to address those issues that we see most commonly from our clients. So if you bear with us, I think we'll likely get to most of the things that you might have front of mind. And then we will have a question period at the end to address any other issues. And during that question period, my colleague from Montreal, Patrick Essiminy, will be joining us in case there are any Quebec-specific issues, because I don't touch Quebec as a policy. Okay, so let's get right into it. What we're going to do basically today splits itself neatly into two sections. One, the fundamentals, and two, the disability management case study. The fundamentals really will just be the primer on the legal backdrop that acts as a framework for these types of issues, and then the case study will take you through sort of, again, something that we see quite commonly, and it'll walk you through all of those various decision points that you have to participate in as you're managing these issues. Okay, so the fundamentals. In Ontario, there's a legal framework that informs our decision-making process, and it consists of the Human Rights Code, the Accessibility for Ontarians with Disabilities Act, the Workplace Safety and Insurance Act, and the Occupational Health and Safety Act. Now, today, the focus will be on the Human Rights Code. We can't deal with all of these various pieces of legislation in the time we have, so we chose the one that really does play the biggest role, and the one that we need to be the most mindful of as we walk through this process. So the focus today will be, when you hear us refer to the code, it's the Ontario Human Rights Code. So your first open poll of the presentation: what percentage of Canadians over the age of 15 have a disability? Okay. No, we're still moving a bit. No. Okay, so it is 20%. So I see that some people have overestimated, which I think, again, brings into focus how often we're dealing with this issue in our workplace these days. Now, just a quick refresher on the types of disabilities that might present themselves in the workplace. They generally fall into these groups: physical disabilities, mental disabilities, and evident or non-evident. So when you say the word disability, what often comes to mind is, mobility issue, perhaps a sight issue, perhaps a hearing issue. Those would all be evident physical disabilities. There are also obviously non-evident physical disabilities, such as perhaps high blood pressure, perhaps a heart issue, other types of non-evident physical disabilities. There are also mental disabilities. Some I would say the one that everyone thinks of these days, anxiety, depression, often non-evident mental disabilities. So you have to keep those in mind as you're moving through this process. Also, every employer's favorite topic, duty to accommodate. So pursuant to the Human Rights Code, employers are required to accommodate their employees up to the point of undue hardship. Now, this applies to all grounds of the code. It most often, in our experience, relates to these types of grounds, so disability, age, creed, sex, family status. And your duty to accommodate is procedural and substantive. So it's about the how and the what in terms of when you're walking through these accommodation issues. And Alex will get into the duty to accommodate and the threshold of undue hardship a little bit later in more detail, but suffice to say it is an extremely high threshold, particularly for those of us in the room today being, significant employers. So your next open poll, because we're curious about this. In your experience, what is the most often requested ground of accommodation? Oh, thank God we picked the right topic. Okay. So we were actually quite nervous of this lesson that would come in, like it'd be like creed or something, and then we've got something that's not very useful to you, so this is great. We did it. Now, when you're looking through when you're looking at an accommodation issue, the principles are really sort of the lens through which you should view these issues. And what you're working towards with accommodation measures are accommodation measures that preserve someone's dignity. So they include their privacy, their confidentiality, they make them feel comfortable, they provide them with autonomy. You're looking to individualize accommodation measures. So this is certainly a place where one size does not fit all. So what you did for Steve, who might have had an anxiety disorder, does not work for Sally, who might have an anxiety disorder. They're not one and the same. Inclusion. So we want to ensure that persons with disabilities that require accommodation feel as though they're integrated into the workplace, are able to participate in the workplace, and that there aren't barriers to such participation. So those are the principles that you just always want to have in the back of your mind. And now I'm going to transition over to Alex, who's going to run through a few more slides.
Fantastic. So thank you, Kathleen. Good morning, everybody. Now that we have some background, let's try and put this a little more practical. Let's talk about what employers and employees must actually do. So given the audience, I thought it would be appropriate that we start with the employers. So employers have a duty to accept requests for accommodation in good faith, except when there is a legitimate reason not to. Often we see employers that are questioning the legitimacy of an employee's request for accommodation because they just know that the employee is not being legitimate or authentic. When we think about what is a legitimate reason to question a request for accommodation, we need to look at this objectively. Would we be able to bring this to a third party, explain our story? Would they believe us if we did? Do we have any documentation that backs up our story? So when I think about a legitimate reason, one of the examples that comes to my mind is that an employee has, for example, requested vacation time. They requested 2 weeks of vacation time, you've denied it, and just so miraculously, they happen to require accommodative leave for that same period of time. So employers also have a duty to get expert opinions or advice. Remembering back to Lucy's presentation, employers shouldn't be using Google in place of an expert. Specialists like doctors or ergonomists become very important in these types of circumstances because we are not medical professionals, and nor is likely anybody else in the room. Employers have to take an active role in the accommodation process. The employers actually know their workforce and their workplace much better than a single employee would. And so you cannot and you should not want to be a passive observer in the process. Employers have to keep a record of requests that are made and actions that are taken. And we find that a lot of employers miss opportunities here. And remember that keeping the record actually serves two purposes. First, it sets the expectations and the parameters for the employee. And second, you're actually building your file in the event the matter becomes adversarial and you need to defend your actions. What you want to be able to show is that you've done everything you needed to do and that you've done it reasonably. So when employers bring a matter like this to us, and to me specifically, and they turn over a huge file to me, I'm actually a really happy camper. So employers want to limit requests for information to what is reasonably required to assess the need or the restriction. A lot of times you see employers asking for something like a diagnosis or even the cause of a disability. You know, did the employee fall down the stairs? Well, these could be relevant. We'll talk a little bit later about what types of information an employer could and should not request. So employers have to grant accommodation requests in a timely way. So we can't just sit on this accommodation process for months and months and months while we sit and think about what might be appropriate. We need to move quickly, because remember, we are trying to encourage full participation in the workforce. Employers must pay the cost of medical information, because we don't want financial barriers to exist in obtaining the medical information that we as the employer need. Financial barriers should not inhibit the accommodation process. And if we do find that there is undue hardship, and I'll talk in a moment about what that means, we have to be prepared to explain it, and we have to be prepared to show it. So moving on to employees' duties. Broadly, employees have a duty to start the accommodation process and to collaborate in the process. So for example, they have a duty to request the accommodation, but remember Lucy's presentation on the duty to inquire. If there's been a substantial change in an employee's performance, we might have to look a little into the reason for that. Employees have a duty to explain why accommodation is required, to make their needs known, and to avoid later dispute. We often prefer, as lawyers always do, that this be in writing. They have an obligation to answer questions or provide information about restrictions, and to participate in discussions on possible accommodative solutions. In addition, they have an obligation to cooperate with the required experts, so they can't just sit there in the doctor's office, provide very limited information so the doctor has nothing to make their assessment on. And this one I think is probably one of the more important ones and the ones we get a lot of questions on, but employees have to meet the performance and job standards once the accommodation is provided. This often gets lost in the accommodation process. Remember again that the accommodation process is designed to encourage full participation. It's not actually designed to relieve the employee of his or her obligations to meet performance standards. So later in this presentation, Kathleen's going to talk about performance management in the disability context and some of the pitfalls that come from that. Employees also have an obligation to work with the employer on an ongoing basis. Too many times we see employers and employees even to sort of set this and forget it. The accommodation must actually be reassessed, reevaluated, tweaked, and changed. Maybe your operations no longer support it, or your operations have changed in such a way as to make it inefficient, impractical, something like that, no longer appropriate. Or maybe the medical no longer finds that accommodation suitable. So we recommend that it be revisited if there is a change in circumstances. So maybe the employee has a development on the medical side, or at another reasonable interval. Maybe that's weekly, maybe that's monthly, maybe that's annually. How often depends a little on the accommodation and what medical information you have to support the restrictions. And the last duty an employee has is to discuss their accommodation needs with only those that need to know. And for reasons that Kathleen will talk about in a bit, controlling the information becomes a very important part of the process. So what is undue hardship? You'll recall that we have an obligation to accommodate to the point of undue hardship. Undue hardship is a defense under the code, and it's the employer's obligation to prove that defense. Our Human Rights Code in Ontario sets out only 3 items that can be considered in assessing undue hardship. It's cost, outside sources of funding, if any, and health and safety requirements, if any. So that means we can't consider things like inconvenience to our operations, maybe resentment from other coworkers, or even our customers' preferences. So employers must demonstrate that undue hardship exists with reference only to the cost of the accommodation, taking into account outside sources of funding, and health and safety requirements. And to be clear, the word undue is not a mistake. It's not used as a misnomer. The word undue is very intentional. It makes it clear that some hardship, and even significant hardship, has to be tolerated. In fact, as Kathleen mentioned, the case law has established a very high threshold for this. In fact, it's very difficult to reach, and in many cases almost impossible to reach the level of undue. We found that our adjudicators have been very unsympathetic to the notion of costs, particularly on large employers, as many are in this room. They are viewed as being able to just simply bear that burden. but health and safety concerns have been a lot more sympathetic. But we need to move away from things like subjective evidence or we feel like it's an inappropriate accommodation. The evidence that we need to be able to present to establish this must be objective. It has to be real and not that theoretical. It has to be directly linked to the accommodation request. And with respect to cost, it actually needs to be something that's quantifiable. So we can't just say it's really expensive. We have to look at it. We have to assess it and determine whether or not it is something, a cost we can bear. So let's talk about some common examples of accommodations in the employment context. So accommodations may include modifications to things like buildings and facilities, policies and processes, performance goals, conditions, or requirements, decision-making practices, or methods of communication. As you can imagine, we've seen a pretty wide range of accommodation requests. Commonly, we see things like job restructuring or changing duties, modifying workstations, perhaps implementing a standing desk. It's very common at Stikeman, and granting leaves of absence. So we've got our next poll. It's time for you guys to weigh in. If you can tell us in a couple of words, what are some accommodations that are being requested at your workplace? And while we wait for those to roll in, I think it's appropriate for us to go over some of the ones that we've seen. Nancy Ramallo dealt with one where an employee was medically required to sleep during certain intervals while on the job. I had one where an employee was unable to wear a suit jacket due to a profuse sweating issue.
Despite being employed by?
Despite being employed as a suit salesman.
That's the key point, really, that you need to appreciate.
Which made it pretty, a pretty difficult accommodation because that was seen as part of their uniform and part of, their branding. Yeah. So Kathleen, what's some unusual accommodation requests you've seen?
Well, I'm sorry, was my, okay. I don't know why, but I seem to get every strange animal request that comes through the doors of Stikeman Elliott. So I have seen a person that needs to have their bunny with them at work because it's their tether to reality. I've seen somebody try to have a snake as a service animal. Really, just about any animal you can think of, I've dealt with it likely at one time or another. I don't know why, they just seem to find me. Oh wow, we're getting really good feedback here. So, okay. Oh, a new boss. Well, that's interesting. Great. Lauren, I don't want a new boss. We're fine. That wasn't mine. Different office. Okay. Some of these, obviously, ergonomic chair, day off per week. Standing desk, restricted hours, vacation. So we're seeing a lot of hours. Modification to hours, modification to location. I don't want to, Calvin, was that you? Okay. Computer screen. So it's interesting, right? And I think this highlights, as we saw in our poll earlier, it was disability followed very quickly by family status. And I feel like those two grounds often do result in these alternative work arrangement requests, working from home, working reduced hours, having a flexible schedule, et cetera. So those intersect there. And then time off to observe religious prayers, that's different lighting. Like, are you Mariah Carey and the lighting is just not flattering you at that angle? I wonder. No, I'm just joking. I'm sure there's a medical issue for that. Okay, well, this is really helpful, and I think it's really interesting to see what we're all getting in our own workplaces. And I wonder how much of this is informed by millennials. Just joking. Okay, Alex, I think I turn it back to you.
And what's interesting is actually when we were testing the polls, we received an accommodation request to not have to be at the presentation from one of the associates giving the presentation. No names. So I actually turn it over to you at this point to talk about what happens when things go wrong.
Okay. Too cold under the vent. Oh, I apologize. Our accommodation is you can relocate wherever you want, just not to the lunchroom at the back. You have to stay here. Okay, so now we get into the sort of depressing part of the conversation, which is what happens when you allegedly fail to accommodate an individual and then have some potential discrimination exposure as well. Now, I'm sure we've all seen demand letters from illustrious plaintiff counsel advising you that they're going to take you into every jurisdiction possible. So if that is the case, you've seen these jurisdictions set out before you. And I'll say that while theoretically you could end up at the Labor Relations Board or the Ministry of Labor, it's a really winding path that's going to get you there. So we're not going to spend time on that today. The two, I would say, real and present threats are civil court and the Human Rights Tribunal. So that is going to be generally our focus for this portion of the presentation. So at civil court, so at your Ontario Superior Court of Justice and whatnot, discrimination in and of itself is not an independent action. So if the individual is simply saying, you have failed to accommodate me, you have discriminated against me, they cannot march off to civil court and commence a claim. They must tie that allegation to an actual independent action. And the one that we see nearly always is an allegation of basically wrongful dismissal, whether it be you did in fact terminate me as a result of perhaps activating the undue hardship threshold, saying we can't accommodate you, therefore we must terminate your employment, or constructive dismissal. You've made my working conditions, you've altered them fundamentally, and there's also these allegations of discrimination. So that's usually how you see yourself ending up at the civil court. The courts can make orders of monetary compensation, including for injury to dignity, feelings, and self-respect pursuant to the code. They can also make other restitution orders, but these awards are generally low. When you look at the court and what they award pursuant to the Human Rights Code, and you look at the Human Rights Tribunal and what they award, there is a disparity. And maybe that disparity really just simply is because you have this other action that they're already providing some form of monetary compensation for, like a wrongful dismissal. So they tend to just add this as what I like to call the sort of kicker at the end, versus the tribunal where the focus really is more on the allegation of discrimination. So with that, we'll move over to the Human Rights Tribunal. And anyone who has had to, has been brought into this jurisdiction with their employees knows it's just a barrel of laughs. The tribunal can award two types of financial compensation. The first is general damages, and this is that curious alchemy that the tribunal does where they try to arrive at a monetary amount that compensates somebody for the right to be free from discrimination, and including their injury to their dignity, feelings, and self-respect. So it's that intangible thing that they're trying to compensate you for. It typically ranges from $1,000 to $40,000, but it does depend on how egregious the conduct. And I will say that in about 2012, there was a review of the human rights scheme in Ontario, and the Ministry of the Attorney General made recommendations upon this review. And one of the significant recommendations was these general damages awards cannot be seen by businesses as just a cost of doing business. They need to be more significant. And so since then, we have seen a few decisions take that on and really increase this general damages award. For example, there was a 2018 case called ABT versus Joe Singer Shoes. It was rendered in 2018 by the tribunal, and it was actually appealed to the divisional court in 2019. And the divisional court dismissed the appeal, so the decision stands. And in that case, they awarded $200,000 as general damages. And as you can imagine, that's very significant. This was in relation to a case where an individual was employed by this effectively the shoe store. She also lived above the shoe store, and the owner of the shoe store just sexually harassed her for a period of years. She was a new immigrant. She felt powerless. It was really egregious conduct, and the tribunal awarded accordingly. Another example is a 2018 case called GM versus the tattoo parlor. This was again a 2018 case. It involved the sexual harassment of a minor, a 15-year-old that was apprenticing at the tattoo parlor. The owner of the tattoo parlor was actually a close family friend. It's just the worst facts. And the tribunal awarded $75,000 in general damages in that case. So as you can see, they are trending up in certain circumstances, so it should not be viewed as, oh, worst case scenario, even though it's still a lot of money, $50,000, and then we focus on specials. We really do need to give some heed to the generals. Now, special damages are the compensation for the financial costs that are experienced because of the discrimination, and it's meant to sort of make them whole, put them back into the position they otherwise would have been had they not been discriminated against. So this is a bit easier to work out sometimes, but it's still difficult to predict in advance. For example, and this is just an example, what you will see from time to time is you terminate somebody's employment, and then it takes, let's say a year and a half to get them to trial. If they haven't found a new job, we've seen special damages awarded all the way to the time of the hearing. So even if their common law notice period might have been 6 months, they get that money all the way through to however long it takes them. So it can be significant as well. Now, the tribunal also has non-financial remedies, and the most significant of these is the power to reinstate the individual to your workplace. This is a power that I think from time to time is taken less seriously by employers, despite the reality of it being quite alarming. You sort of think, well, obviously the relationship is broken down to such a degree, who would ever order this? It doesn't serve anybody's interests. And I would say that is still generally a reasonable position to take, but from time to time it does come into play. And one of the most significant decisions in this regard was in 2013, Fair versus the Hamilton Wentworth District School Board. A woman went off work. She was in charge of asbestos removal in the school board's properties. She developed an anxiety disorder because she was terrified of somehow being held liable under the Occupational Health and Safety Act in relation to her job. She then progressed from STD to LTD. Similar to our case discussion later, she was able to come back from LTD, said, I'm ready to work again. They said, oh, sorry, we don't have a job for you, despite having other similarly situated roles available within the organization. It took 8.5 years from that point to make its way through to a decision by the tribunal, and they reinstated her and awarded $420,000 in back pay. So despite being out of the workplace for nearly a decade, and, you know, they found it was a justifiable result, and that was appealed as well and dismissed as well. So it still stands as good law. So there are also other orders that can be made. So human rights training in your workplace, posting a copy of a decision, which as employers, that's obviously not ideal, a decision adverse to you, and posting a copy of the code in the workplace. So that's generally the sort of galaxy of remedies pursuant to those two jurisdictions. And, you know, we also want to talk about the hidden costs, because it's not just all about money. And with that, I think that millennial presentation we all just heard, front of mind, again, this is something that historically, traditionally, employers have said, oh, okay, yeah, I suppose, but it's not really been a focus. And I think it's becoming more of a focus, because in this age of easy communication, like you saw, you know, Slack and Skype and texting and this sort of not turning off and shutting down and going home, this bleed through of work and home, I think it's reasonable to expect that if you're running through an accommodation scenario with somebody else is also going to know about it in the workplace, and then somebody else might know, and somebody else might know. And if the employee feels that he or she is not being treated respectfully or properly, despite that being the case or not, this could affect your employee morale, your productivity. It could lower engagement. It could result in the employer having a difficulty recruiting, loss of diversity, et cetera, et cetera. So I think, you know, how we engage in this process, the perception, realizing it's not always reality, the perception of the individual engaging with you and how they leave the process is still important from this, you know, the risk is there not only from a financial perspective of doing it quote unquote wrong, but also from a hidden cost perspective. And so now we are going to get into our case study. And I'll remind you that you have this folder in front of you. And please, if you could, take out your fact scenario. That's going to help ground you in where we are, because it is a long and winding path we're going to take you down. And also the decision tree to help, again, keep you on pace with Alex and I as we make our way through this.
Okay. So I think at this point, everyone is an expert on the fundamentals. Everyone in the room knows exactly what they need to do. We all understand our duties. We all understand the consequences, the risks if things go wrong. So we'll move into the case study. And so everybody, I assume by now, has the decision flow chart in front of them, which my wife pointed out to me last night looks like a series of larger houses, one after another.
Oh, it does.
I think Augustine Matthews' house is the back one. So we want to remind you that this flow chart, while very helpful for our discussion today, is not actually a golden ticket. These matters often prove to be extremely complicated. You may end up running down the same pathway 10 times in a row, or one pathway may suddenly actually twist and become a completely different one. As I think I've heard Kathleen say in the past, working through these processes is a little bit like hide and seek in a factual minefield, and no one knows where the mines are. I think that's correct.
Oh, it's choose your own adventure.
Close.
In the middle of a minefield.
In the middle of a minefield.
Yeah.
So today, let's think of this flow chart as our skeleton, and through our process, through our case study, we're going to put a little bit of meat on the bones. So today we're going to talk about Laura. Laura's the director of marketing, and she's been having some very significant performance issues at work. She's had extreme difficulty being punctual and meeting some very crucial deadlines. So Laura's manager has spoken to her, let's say, over and over and over. And then last week, Laura raised a concern to the HR department over her manager's management style, which she found both intimidating and unapproachable. Laura's manager has become very frustrated with the relationship and wants to end it. She wants to terminate the relationship. However, before the termination meeting, Laura provides a medical note. The medical note says that Laura needs to be off work for 2 weeks for medical reasons. So Laura's come to HR or legal, depending on who you are, to ask for some advice. Looking around the room, I saw a few nods, so I can tell that you've all seen the medical reasons note. So we've arrived at our first stop, the initial accommodation request. So what do we do? Where do we start? Where do we go from here? So let's start by analyzing the request. So first, I want to look at the context of the request. Remember that Laura made a complaint about her manager just last week. Her manager was intimidating, unapproachable. And as we start to peel back that onion, there may be more concerns. Notably, Laura didn't actually use the word harassment, but there may still be an obligation to investigate under the Occupational Health and Safety Act. The word harassment is not somehow a magic word. We need to look at the substance of the interaction. Now, investigations can be their own very lengthy presentation, and we are, of course, happy to speak after if that's something that would be helpful to you. But for today, let's assume no investigation is warranted. It was interpersonal difficulties. We do want you to have your antennas up at this stage. So next, let's look at the actual accommodation request. Remember that the note is vague. It's probably about as vague as it can get. It doesn't use the word accommodation, doesn't use the word disability. We do have to look at the substance of the note. Again, not the form. So unless Laura was somehow perhaps tipped off about her termination, there doesn't really seem to be a legitimate reason not to accept this request for accommodation. So we should probably accept it in good faith. So now what do we do? How do we respond? So first, let's think about our communications to Laura. Because we are, of course, a very caring employer, we want to stress the importance of Laura's health. We want to set out the terms of the accommodation. So what days is Laura going to be off? When is she expected to return? Things like that. We want to advise of any compensation that's available. So maybe Laura has vacation pay that's accrued and available. Maybe she has sick pay. And then second, we want to think about our communications to other employees. So Laura's going to be off for 2 weeks. It's a pretty long time in the business world. So we're likely going to need some internal coverage because marketing, surprise to some people, doesn't actually run itself. So who needs to know and what do they actually need to know? And I'm stressing the word need, not want or would like to or would be helpful. In this case, Laura's team probably needs to know. Laura will not be there. But what is it that they need to know? Do they need to know that there was a medical request, that there's a request for accommodation? No, not in this case. All they need to know is that Laura's going to be off and that she's not expected to return for at least 2 weeks. So we need to think critically in our organization if there's others that need to know, maybe outside Laura's team. So let's add some new facts to that. On the day before Laura's supposed to return, she submits a second medical note. Again, it's the infamous medical reasons. This time, it's for a period of 4 weeks. So we move on to our second accommodation request. Now, this one we're going to deal with a lot like the first, but perhaps a little more critically, because this is the second time we've seen this. So again, we're going to start by analyzing the note. Is the note sufficiently detailed? Again, the note only said medical reasons. So we're balancing the employee's right to privacy versus our need for information. In this case, it's pretty clear that the note isn't detailed enough. And so we're going to need to request further information. We do need to remember that the request for notes must be reasonable, both in what we're asking for We'll get into that in just a second. And how often we're asking. So are we asking every day? Are we asking every week? When are we asking? Before we move on to what we can and can't request from Laura, I just want to take a moment to talk about the author of the note. So if the answer is this is a note written by a doctor practicing in a medical clinic, it's probably a pretty easy answer, right? They're an expert in the field and we take their advice. But what if, for example, the note was from a nurse practitioner or a registered massage therapist or even a social worker? Originally, we saw a lot of pushback on the nurse practitioner, but now it's actually become quite common to accept notes from nurse practitioners in much the same way as you would a doctor. The RMT and the social worker actually are a little more difficult. There's been some significant divide in the legal community about the appropriateness of notes from these individuals. Our practice is to look at, first, our benefits policies. So for example, if we provide reimbursement for RMTs, it starts to become a little difficult to suggest that they are medical enough for reimbursement, but not actually medical enough for a note. But we also need to think about the content of the note. Is the accommodation request actually within the realm of the specialization? So that can be difficult at this point when we don't have a lot of information. But if, for example, our RMT is telling us that our employee needs a support animal, we'd probably want to look pretty critically at that. So what medical information can an employer ask for? Employees are typically expected to provide confirmation of the existence of a disability. Remember, we're stepping out from something that could be just a cold and they need a day off to something that is a disability within the meaning of the code. Information on their limitations or needs. Confirmation that the employee can or cannot perform the essential duties of their job with or without accommodation. The types of accommodation that might be required, if any, and the return to work date or the employee's next assessment date. Employers are not typically entitled to receive an employee's confidential medical information. So this includes the cause of the disability, how it happened, where it came from, the person's diagnosis, symptoms, or treatment. The only caveat that I put to that is if the information clearly relates to the accommodation that's being requested. So when we look at the issue of medication, for example, medication can be a very touchy subject because it can often provide a window into things like diagnosis, symptoms, and of course it is the treatment. But it can actually be quite relevant as well. So if, for example, an employee as their job drives a forklift and they take a medication that makes them drowsy or affects their judgment, that medication may actually be extremely relevant. So let's add a few more facts. We have a very ambitious HR rep. Perhaps she is a millennial. She emails Laura and says, a generic doctor's note is not sufficient. More details are needed. And Laura, you have 3 days to respond. She apparently took to heart the fact that accommodations must be requested and granted in a timely way. So Laura, unfortunately, does not respond before the deadline. At this point in time, I received probably the most common question, Laura is not cooperating, can we fire her now? And in fact, I can actually hear that in the voices of some people in the room. But let's peel that back a little. So, some considerations. Do we have confirmation that Laura actually received this correspondence? Do we even know if she's checking her email? How could we possibly know that? Did we use everyone's favorite tool when something is urgent and you want someone to read something, the read receipt? Could there be another reason that Laura hasn't answered? Has Laura's disability prevented her from being able to answer? Was the timeline too short? Short answer, yes. Or is there a financial barrier? Functional ability form assessments can be quite expensive. I actually had a case where an employee appeared to not be cooperative, and we reached out to them over and over and could not get them to respond. But before we moved forward with the termination, we decided to give it one more, last shot by the telephone. And it turns out that the employee's spouse answered the phone. The employee had been in a car accident and was hospitalized, and that is why they were unable to answer. So just imagine if we'd gone forward with the termination a little too quickly in that one, how that would have looked. So we also want to think about our own actions in this. Was HR's request actually clear? Did we tell Laura what we needed from her? In this case, we wanted more details, but What details were those? So our recommendation in this case to HR would be to reiterate and to clarify the request, to try some various means of communication. Perhaps that's a letter, perhaps it's a phone call. To stress the importance of collaboration in the accommodation process, we need to remind Laura that she has duties too, that it's not just all on us. And we need to offer to pay for the doctor's note, remove that financial barrier from consideration, and then you'll probably see this on a number of slides, document, document, document. So documentation should include when was the email sent, who was it to, copies of any follow-up, was there a voicemail, who left it, some notes from that, and keeping a copy of that in the file. We also want our documentation to build on itself, reference prior documentation. So when we reach out to Laura again, we're going to say, as we didn't receive a response to our last email, and perhaps even attach a copy of the email. So in this case, HR clarifies and reiterates their request. This time they try by email and registered letter, and they call Laura. And Laura, in this case, hastily responds, apologizes. She's had a death in her family. So just imagine what we all just avoided. Laura provides a more detailed note. She completes her functional abilities form, and her doctor confirms that she's medically restricted from performing her essential duties, and she's going to be out for at least 2 weeks. At this point, we typically see matters take one of two pathways, and it depends on whether or not you have an insurer involved in the equation. So I'll turn it over to Kathleen to discuss option A.
Thank you, Alex. Okay, so because I lost an epic game of rock, paper, scissors, I get to do the employer adjudication split side, so in option A. And what we'd like to know from those in the room and those via webinar, does your company maintain an insured short-term or long-term disability plan? And you'll see you can have no, short-term, long-term, both, or just not sure. Okay. Well, that's actually quite interesting. Okay, so we have 3% saying no for an either, 5% for short-term, 34% for long-term only, and then 56% for short-term and long-term. It's very interesting. Okay, so what I'm going to be using that as our background, I'm going to be talking about the employer adjudication option. And for those of you in the room thinking, oh, well, this doesn't apply to me because our company has short-term disability through one of the lives, Manulife, Sun Life, et cetera, or, we have both of them. So I'm just going to, sort of check out here. Don't check out, because this would also apply if your short-term disability insurer denies the claim. So you would then also be in this bucket of, as an employer, you're caught in that funny space of, wait, well, the employer denied the claim, but this person's still giving me medical notes saying they can't come into work. What do I do now? So this would be applicable to you. Okay, so we've now made it down to employer adjudication through the A split pathway. And this, as I said, is applicable if you do not have a short-term disability benefit plan, or if the employee at question has been denied pursuant to that plan. You, as the employer, are the decision maker. And this road generally comes to an end with the employee returning to work without restrictions, the employee returning to work with restrictions, or the employee just simply doesn't return to work. And we'll explore all of those now. So I would say that the biggest issue facing employers in this scenario is dealing with the medical documentation from an individual, because again, it's you, it's nobody else. There's no third party reviewing and making people submit the documents, et cetera. So you, at first instance, you have Laura. Laura submitted 2 medical notes. We've now know she's going to be reassessed in another 4 weeks, and we're trying to figure out what to do next. So often employers will call and ask, well, how often can I request medical documentation from Laura? I don't think she's being quite honest with us. I think she's a malingerer, and I want to make sure I want every week Laura to provide me with a medical note. Well, that's not realistic. And so there's this balance between, being reasonable and also having your needs met in terms of keeping the individual engaged and honest. And I would say that in most instances, the notes themselves delineate the frequency. So in this case, we see that Laura is going to be reassessed in 4 weeks. It would seem a bit odd if between now and 4 weeks from now, we're going out to Laura and saying, get us a new medical. She would say, why? You saw my doctor's note. I'm being reassessed in 4 weeks. What am I supposed to get you between now and then? So often I let that be my guide up to a certain point. There does come a point likely when you need to get a bit more in the mix, but at this stage, I think that would be your guide. And then you go into the content of the notes. As Alex said, we should not be asking for any information regarding diagnosis. It should be prognosis only, restrictions, if any, that are applicable, and keep it to that. You don't want the classic, corner urgent care clinic person saying, the factory just churning out absent, cannot work, and that's all you get time and time again. But I think you also want to be careful about what you do and don't ask for, and we'll get into that in a little bit more detail later. What we also hear, and often at quite an early stage, is an employer asking, can I get an independent medical? I've never heard of this doctor before. I don't know. They're probably a friend of theirs, or it's some factory on a corner. I get notes from this doctor all the time in my organization. I want independent medical. And this is where we throw up a big caution sign, and we say, independent medical, legally, you are only entitled to request it from an employee if there is an objective basis for that request. And quite honestly, nothing that I just sort of threw out as an example for requesting it consists of an objective request. You have to think on an objective basis that the information is inaccurate or it's inadequate. And then, and only then, could you have any foundation for requesting it. And you also can't force an individual to attend it. Obviously, it would be not viewed positively if they refuse to attend independent medical, but it's not something you can force them to do. And ultimately, the independent medical, or the IME, is not this solution in most cases that employers think it is. I mean, let's take the example of a mental health issue. You have an individual who's been treated by a physician for mental health for a period of time, and you believe there's a basis to not trust that medical documentation or that person's evaluation of this employee's disability. You require an IME. All that IME is really going to consist of is a doctor who's never seen this person before being told by this individual what their symptoms are and saying, this is what she told me. I don't have any reason not to think it's true. So great. And now you've spent all this time and all these resources on something that's of very little use. Or what do you do if you get a IME back that conflicts with the medical evidence you have to date? How do you evaluate that? On what basis do you establish that your expert is better than their expert? And so it's not always a simple answer to a complex problem. In fact, it's just another layer of complexity. So I would say use caution, reserve it for only significant circumstances, and reach out to us before you embark on that particular process. Now we'll go through. So at the end of her leave of absence, Laura is ready to return to work without restrictions. Which would, on the face of it, seems quite wonderful. What does that mean for us? Well, often the next question that I will get from a client is, okay, Laura's ready to come back to work. Do I need medical clearing her to come back to work, or do I just welcome her back with open arms? And again, this seems like a very simple issue, but as all things law and all things disability management, not so simple. You might even have a varied response amongst legal counsel in terms of this type of an issue. And I know discussing it internally, we all had sort of different shades of gray on this one. So my own personal perspective is, if it's something very self-evident and relatively simple. So let's say the person had a minor surgical procedure and they were home for 6 weeks, now they're ready to come back. Okay, what's the worst that can happen? They come back in, maybe they're not, maybe they get in touch with you, you work it out. If they broke their legs healed, come on back to work. Like, these are all relatively simple. I wouldn't say, oh yes, you must get a medical clearance for that. I don't think you need to. But again, let's go back to an issue that we're all dealing with these days, which is mental health. Somebody has been off. We don't know what it is. Often we all have some sense of what's going on in the background with these types of issues. And that person out of nowhere says, and with no medical documentation sort of leading you to believe this is the case, okay, I'm ready to come back. I'll see you on Monday. And it's the Friday before. Well, your initial reaction might be, oh, that's great. Your secondary reaction might also be, ooh, do I trust that? Do I think that's safe? Is it safe for them? Is it safe for others? I don't know the answer to that. In those cases, I generally say, ask for medical clearance, continue to pay them while they're off, pay for the note that they need, make it easy for them, be kind, be sympathetic, but, say we do, our policy is that we do require this. I've had individuals multiple times with clients saying, I'm ready to come back, can't wait to see you. We insist on medical, and the medical comes back saying they're absolutely not cleared to come back to work. So you have to consider the circumstances and be sensitive to those and use your judgment, or just call us and use our judgment. Another question. Recall Laura was being performance managed to a certain extent. She was having performance issues before she left. We were about to terminate Laura when we got the medical note from Laura. So 9 times out of 10, the employer says, okay, Laura's coming back. We were ready to terminate her. Can we performance manage her, or can we effectively, am I hitting the right one? Yeah, sorry, I got ahead of myself. Or can we terminate her? And both reasonable questions to ask, certainly. We would say, again, be cautious in this approach, because you might have a situation where potentially Laura's performance issues were tied to the disability she was experiencing at the time. And perhaps when you welcome her back into her workforce, they've resolved, she's fine, everybody can march off into the sunset together. And if not, and Laura does come back and she is exhibiting performance issues, you can absolutely performance manage her. This does not put her in a bubble of protection forevermore. But you also just want to have that, both sides of this issue in the front of your mind as you go through this process. I would not recommend immediately moving to termination when Laura comes back, again, because what you're most likely to be faced with is Laura saying, those issues I was having were because of my disability. I'm now approved to return to work. You never gave me the chance. You've just moved forward, and lo and behold, I take a leave and I'm terminated when I come back. And despite having that email traffic behind, that's not going to be your get out of jail free card saying, well, we knew before we had the note, so therefore there's no way we can be viewed as discriminatory. That will help. It will not solve your problem. So I like to tell clients, and a few of them in the room have definitely heard me use this term before, I want to sever the nexus. I want to get to a place where it's not employee went on leave, employee came back from leave, we terminated employee's employment. I want to put some time there, time to evaluate the individual on good faith basis, time to see if those issues have resolved, time to performance manage if they have not, and then build an objective file towards termination if that is the proper outcome, not simply just, terminate when you come back. Again, this is my approach in most situations, but some may have different factors that would lead to a different conclusion. But the message is use caution. So I would say the more likely scenario these days, Laura is ready to return to work, but with restrictions. So how do we manage that moving forward? So Laura provides a doctor's note saying she's ready to come back on a graduated return to work. She is able to start at 2 days per work week, and she will add 1 day every other week until she's back to full time, and she will require, quote unquote, more frequent breaks. So what do we do with that? Again, we want to remember Laura's essential duties when we're evaluating these types of accommodation requests, because we need to keep those in our mind and think, what is the core of Laura's job? What do we really, really care about in terms of how she is performing and what she is doing for us? And as director of marketing, we would view her essential duties as being she's frequently leading internal team meetings, she's designing and implementing comprehensive strategy, she's assisting in creating materials for proposals and presentations, and she's leading the marketing operations, including media campaigns and promotion. So an integral part of our business. When you look at those duties and the restrictions upon which she is able to return to work, they're vague, right? I mean, what does more frequent breaks mean? I don't know what that means. Does that mean every 5 minutes she needs a break? Does that mean every 2 hours she needs a break? Where should this break be? How should it occur? Does it have to be in a quiet room? Does it have to be so there's all of these sort of unknowns around more frequent breaks. And so we tell human resources, please go back and clarify with Laura exactly what this means. Get that information so that we can put together a strategy that we think addresses her needs and ours. So we find out that she requires an additional 15-minute break every 2 hours. Her restrictions are only effective during her graduated return to work. So the idea is once this graduated return to work period is over, she should be back, no restrictions, no problems. And so we think, okay, great. Our business needs are highest on Thursdays and Fridays. So that's the 2 days a week we need Laura back in the office. So we put together this accommodation plan addressing these issues. Bob's your uncle. It goes out to Laura. We think we're doing great. This might surprise nobody, but Laura had a more preferred accommodation in mind. And that accommodation was, well, yeah, I know Thursday, Friday is the busiest day, but actually I find that intimidating. I'd rather be back on the slower day. I'd rather be back on Monday and Tuesdays. I think that will be easier for me. Now, again, we have to be using our judgment, but at the same time, employers are required to provide a reasonable accommodation, not the perfect accommodation. And it's supposed to be a collaborative process. So I would say sit down with Laura again, talk to her about this, explain your position. Maybe you meet in the middle. Maybe it's a busy day and a non-busy day. Who knows where you end up? But as long as it's a place that you both are, what did Mari say, equally unhappy or equally dissatisfied, then perhaps you've landed on the right solution. Now, what if the accommodation is more difficult? We started with a bit of an easy accommodation, and I know that many people here are getting more difficult accommodation requests these days. So let's add some complexity. What if her medical documentation had other forms of accommodation? What if she can't lift more than 10 pounds? Laura's director of marketing, how often do we think she's actually lifting more than 10 pounds? Probably virtually never. So we've labeled that as green, likely fine, no big deal. Laura needs feedback to be in written form. What does that mean? Laura works in a collaborative team environment. Is this official feedback? Is this just, someone saying great penmanship? I don't, what does that mean? And so again, that would be perhaps a caution flag saying we need more information in order to evaluate whether or not we can offer that form of accommodation. And she requires shorter hours of work. Again, you're back 2 days per week. What does that mean? How does that work? And you're evaluating. It's a constant process. Laura can't operate a computer and she can't interact with her manager. You'll see we've labeled this red. Red does not mean cannot do it. Red means, oh, we're really going to have to think about this one, because Laura is a director of marketing. How does she do her job without operating a computer? How does she perform those essential duties of her role without it? I'm thinking that's a really steep hill to climb, but maybe someone else can surprise me with new technology. And Laura cannot interact with her manager. So recall again, she was having difficulty with her manager before her leave. She's now coming back saying, I just can't interact with him or her. I shouldn't say him. And so what do we do with that? Do we think that's reasonable? Was there any reason to think that there was some significant problem back there when it pinged us at the beginning of the case scenario? So it's something, again, that we'll have to think about, we'll have to evaluate, we'll have to see if it's reasonable, necessary, and move on from there. So again, these are just more your takeaway for home. Remember what the duty to accommodate does not require an employee to do, which is fundamentally change working conditions, assign the essential duties of a person's role to another employee, promote them or compensate them for work not done, or change the essential duties and requirements of a position. So that's sort of, you don't have to do any of those things when you're accommodating somebody. So, open poll. What do you think about this one? Laura needs to work remotely on an indefinite basis. In our fact scenario, do you think this would be a green, a yellow, or a red? And again, we chose this because we're seeing more and more work from home arrangements requested, and some of them are on indefinite. Oop, shut down your poll. Okay. Okay, so I think yellow or red is the right place to park this request. And depending on your own organization, I think that's probably informing your views of this type of a request. In Laura's scenario, given that she was the director of marketing, she was in a collaborative team environment, she led teams, she was implementing strategies, I would personally be of the view that in-office attendance at least a portion of the time is necessary. So to have somebody like that working from home, and not only working from home, but on an indefinite basis, I think that's a very significant, difficult accommodation request. And I don't think an employer would be automatically deemed to be in the wrong for saying, coming to us and saying, I just don't see how we do this. So I agree. I think everyone's on the right track there. So we are now moving on to Laura is unable to return to work. So this has now turned into a significant long-term leave of absence from which we do not think Laura may ever return. And often when this occurs, these are the issues that clients come to us with. What do we do now? Laura's our director of marketing. We don't know if she's ever coming back. This is a significant role in our organization. We need to fill it. How do we fill it? What are the rules around this? Once somebody transfers to a long-term leave of absence, and again, you're not working in your STD, LTD plans because you don't have them in this scenario, or perhaps she has now gone from, we don't have an STD plan, but she's transitioned to our LTD plan. At that point in time, we're generally comfortable with saying, listen, you're on a long-term leave of absence. We don't know when or if you're ever coming back. Therefore, we do in fact need to fill this role, and you don't need to fill it on a temporary basis. You could, if you felt you could recruit and fill it initially on a temporary basis and then transition after say 6 months or a year to a permanent basis. But often clients say, I can't fill this level of role on a temporary basis. I'm not going to get anyone in the door. So let's be realistic here. And realistically, we say, okay, go ahead. We'll deal with Laura coming back later if and when we have to. What do we do about confidentiality? Laura's confidentiality, but also having to tell our employees that Laura's not here, nor do we think she will be here for an immediate future. Generally, the communication is something as simple as Laura's on a leave of absence. It is unknown when she will return. Something as simple as that should be along the lines of your communication. Nothing more than that. What do we do about Laura's vacation accrual? For that, unfortunately, here's the answer. The answer actually is look at your policy, see what it says. Your vacation policy may not address what happens to vacation on a long-term leave of absence, but we would expect that given the increase in these types of issues, that might be an element that we revisit to delineate whether or not you continue to accrue paid time off while you're on time off. It seems counterintuitive, but you do see this from time to time. Under the Employment Standards Act, your vacation would continue to accrue. Your time would, but your wages, effectively, you're not getting paid anything from us, so it would amount to $0. But if you have a policy that provides more than ESA, you'd want to revisit it, check out the language, make sure you're protected from that angle. What do we do about continuation of benefits? We're seeing this more and more. So you have a person that goes off on a leave of absence, they're under your group health and dental insurance plan, and 3 years later, they're still on your plans. And this is frustrating you because you're paying these premiums, this person's using your benefits, you don't know if they'll ever be back. Why do we still have this person out there on our benefit plan? And generally speaking, again, this is ideally a policy issue where you could draft it into your policies and address it explicitly. If you don't have any policies addressing this and the employee's out, it's a difficult thing to then say to them, oh, FYI, you're on a leave, you're likely using our benefits quite a bit if it's obviously medically related, such that medication's an issue, but we're going to take those away from you. Thank you so much. I mean, the risk is that you get a discrimination claim saying, but for my disability, I would not be in this position and I wouldn't have this negative effect. Generally speaking, and while there's no perfect answer to this, my preferred approach is to make sure that the person's been on leave long enough that you don't have a comparator group. So, for example, if somebody's on maternity leave, which now can be 1.5 years long under the law, and somebody's on an LTD leave and they've hit a year and we're yanking their benefits, they could easily say, wait a second, I'm on LTD due to disability, you're yanking my benefits at a year. This woman's on a maternity leave for a year, she still has her benefits. You're discriminating against me on the basis of disability. So you want to get yourself safely beyond what I would say is the longest statutorily protected leave where they can draw a comparison between them and somebody else. And right now under the ESA, that's about 2 years. So you want to make sure, I would say, you're well beyond that so that they can't have an easier argument to make about discrimination. But again, revising your policies is a really good place to start with this. And then termination. What do we do? Can we terminate is often the question that we get asked. So if we're looking at terminating Laura, she's been on leave for a while. We don't think she's ever coming back. We're frustrated. She's frustrated. Everybody's frustrated. We move over to a potential frustration of contract. See what I did there? And what we're going to think about here is whether or not we can say that the contract has become frustrated because it's basically, there is no likelihood that Laura will return to work in the foreseeable future. If you call the contract frustrated, at law, your only obligation to Laura generally would be Employment Standards Act amounts. So your minimum statutory entitlements. Of course, you always have the option of choosing to terminate Laura on a without cause basis. That would, I think, leave you, again, the risk is always that you're left open to a discrimination claim, saying you terminated me because I'm on leave, because I'm disabled, et cetera. And the answer sometimes is, yeah. And then you have to deal with that. But from a frustration of contract perspective, which is the one we're dealing with most often, employers often think, well, she's been gone a year. She's been gone a year and a half. She's been gone 2 years. She's been gone 3 years. How are we still waiting on this? Clearly, she's never coming back. There is an entire process we would lay out for you if you brought this to our doorstep. Basically, first, we would vet how long she's been gone and what medical you've received and whether we think you are potentially in a frustration of contract scenario. And if so, great, we send Laura or her medical provider a letter asking them to basically confirm that there's no foreseeability of a return to work. And once you have that confirmation, you can establish frustration of contract. If you don't get it, then you're back in basically a waiting game, trying to get to that place. So it can be complicated, and we have cases in the case law that go as long as 3, 4, 5 years. So it really is a significant period of time before you can try to avail yourself of that argument. So what if you ask for explicit acknowledgement that Laura's not returning and you don't get it, or what if you just don't have it? Can frustration be inferred? No. You really, to take a conservative approach here and make sure that you've got your ducks in a row, you should not try to infer frustration. You should not try to presume what Laura is or is not capable of. And your documentation should sort of, to use a term, paint that physician into a corner, because often you get back these wishy-washy statements. I like to use documentation or documents put to the physician that basically set out the legal test and say yes or no, and try to nail them down that way so that you can feel confident moving forward that you've gotten the answer to your question. What if Laura is non-responsive or not cooperative? This happens all the time. Somebody's been gone a really long time. You haven't had much contact with them, and maybe you've let sort of lapse this idea of monthly check-ins with medical evidence, et cetera. They're just sort of out there in the ether. What do we do now? We've asked them the question, is there a foreseeability that you'll return to work? We've gotten no answer. We've sent another letter. We've gotten no answer. We've done Alex's approach, which is email, telephone, letter. We've gotten no answer. We've made it very clear what the consequences will be of not responding, and we've gotten no answer. And I would say generally, that should be your process. I mean, you have to show as though you've made every single effort you can to get a response from the individual before you take the step of terminating their employment. And even at that stage, you could choose to terminate with cause or without cause. And it's really sort of your own risk threshold and whether or not you want to release to give you some certainty moving forward that they're not going to come out of the woodwork in 2 years and sue you, how you choose to proceed in that way. But, that's always a difficult place to find yourself. And ultimately, you have to make a call. And with clients that have done this, in my experience, sometimes it works and you never hear from the individual again, and sometimes it doesn't. And miraculously, they get that last termination letter and they pop right up. So it's always a bit of a prediction and analysis. Okay. You're probably tired of listening to my voice. You're probably super tired of Laura at this point, but we're not done yet. The good news is it's Alex's turn to speak, but the bad news is you're only halfway through. So stay with us, buckle up.
So what I actually thought was quite interesting is Kathleen thought she lost the rock, paper, scissors. I'm the one that gets to explain insurance plans to everyone. So I'm not sure that she was actually the one that lost. But let's...
You can vote on that at the end. Let us know.
Let's rewind the scenario a little, right? So we go all the way back up. Remember, we're at the second request. Let's remember where we are with Laura. We had the first note, we had the second note, requested more details. But in this case, we have an insured STD plan. So under option B, as we've lovingly called it, the insurer is going to take over the disability management. So they're going to be requesting and assessing the medical. And similar to the employer adjudication, this process usually ends with either the employee returning to work without restrictions, sort of rare in the circumstances, the employee returning to work with some restrictions, or the employee's disability benefits terminating, and similar to the other scenario, she's just unable to return to work. So let's talk about some benefits of having an insurer for those insurers in the room. Again, the insurers do all the heavy lifting. Typically, they maintain very well documented and comprehensive records. They're experts in this sort of thing. And in fact, they may be experts in crafting the return to work plans. The insurers have seen it all. So they have a fundamental understanding as to what may work and what may not. Most importantly, it avoids the risk of private medical information being transmitted to the employer. So remember back to our discussion on risk and exposure, where even a legitimate decision could be tainted by that knowledge. So we often encourage or recommend employers to retain a third-party adjudicator, even if they don't have an insurer. So you can actually have someone that just assesses your medical and makes decisions on that basis. So at the end of our leave here, Laura is not medically able to return to work. The company provides her with the application forms for an STD. She applies and, surprise, surprise, is approved. So we now move down to the short-term disability benefits. Employees' access to STD depends on their ability to meet the definition in the plan. And it's often policy or plan specific, but typically it's any sort of illness or injury that renders an employee unable to do their job. The wage replacement amount is also plan or policy specific, but typically we see about 3 months of coverage. And usually that happens to line up with the LTD waiting periods. It's a little unusual to have insured short-term and not insured long-term. Usually we find those things go hand in hand. So recently we've seen insurers urging employers to consider whether or not WSIB is appropriate. Remembering Lucy, I think it was, mentioned about chronic and traumatic mental stress benefits. And so a lot of push towards seeing and evaluating whether or not the WSIB is an appropriate avenue. And also to expedite employees back to work. To assist that, we actually have seen insurers asking some very detailed questions about performance considerations and otherwise to determine root causes of things. So we want to remind that in this case, you guys would be the insurance company's client. So if you have concerns, including about return to work plans and timeliness and things like that, you can certainly discuss your concerns with them. So at the end of her at the end of her STD, Laura applies for and is approved for LTD. So we've got first note, second note, clarification, STD, and now LTD. So LTD typically takes effect after a period of 120 days. But what's really important about these ones is there's usually 2 relevant periods for the definition of absolute disability. The first definition is the own occupation. And that typically includes or requires that the employee cannot perform his or her own job. And it's usually for about a period of 2 years. After that, there tends to be a shift to what's called the any occupation. And that requires that the employee not be able to perform any occupation based on the employee's skills, qualifications, and experience. As you can imagine, often it's pretty easy to meet the own occupation threshold at this point, but the second one becomes much more difficult. So back to our fact scenario. Unfortunately for Laura, after 2 years, she ceases to meet the definition of total disability. Remember, we're in the any occupation at this point. Laura's disability benefits are being terminated at the end of next month, and HR has had absolutely no contact with her since the termination of her employment. So you can see we've moved down to benefits terminate. So again, it seems like I keep addressing this question, but I keep getting these common questions. Laura's not eligible for benefits. The insurance company has declared her unable to perform her job. Can we fire her now? So employers shouldn't rely on an insurer's assessment. The termination of benefits on the flow chart doesn't actually lead to the end of the relationship. So I'll just turn back. You can note that it actually doesn't go directly to end of relationship. This isn't actually an oversight on my part in preparing that. The question of whether or not Laura is eligible to receive benefits is a separate question from whether or not Laura can perform the essential duties of her job, either with or without accommodation. So at this point in time, what do we do about Laura? Well, first, I always suggest that we all give a very collective sigh, and then we can continue on with the accommodation process. So we actually go back to Kathleen's portion of the presentation. The employer is back as the adjudicator. We request medical. Can the employee return to work with or without restrictions? Evaluate the accommodation request. Does it cause undue hardship? And so we'll leave you with some key takeaways in case you got stuck answering emails while you were doing one of the polls. The 4 key takeaways that I thought might be helpful in this presentation are that to remember that employers and employees have very extensive accommodation duties, that accommodation must be granted to the point of undue hardship. In crafting accommodation solutions, we need to remember those principles of accommodation. They need to always be floating in the back of our mind: dignity, individualization, and inclusion. And most importantly, because I keep stressing this point, communication, cooperation, and documentation, all in capital letters, will be key. So we want to leave you with one last opportunity to weigh in, and we think it's really important that we get this feedback from you, and we really hope that you'll give us your honest opinion. Was this presentation helpful?
Oh, wonderful.
That's great.
Anyone else? Also, Patrick, is there anything from a Quebec perspective that you want to layer on to what we've said in terms of this issue for those in the room? Yeah, come on up.
So I would say in Quebec, a lot of the rules you talked about are the same. And again, our Labor Standards Act has specific statutes. So anyone who is absent on sick leave is protected for 26 weeks, which means that anyone who has less than the 2-year rule that I talked about earlier, who is absent for sick leave, has a right to return in their position if their absence has lasted less than 26 weeks. And whereas this protection only applied to employees who had acquired at least 3 months of service in the past, starting in June 2018, that 3-month condition has been removed. And therefore, an employee, as of day one, has the right to be absent on sick leave and return to their job. The second thing that we also see in Quebec is for employees that have less than 2 years and don't have a right to file a complaint for unjust termination, a lot of the accommodation debates happen at the Human Rights Commission or in arbitration when it is a unionized workforce. And the last thing, talking about managing a leave, is because of our psychological harassment provisions, which are very liberal and very open to all the employees, when an employer attempts to overmanage a leave by calling the employee, asking for documents, asking for information, that often turns into a harassment allegation against the employer. So we often caution our clients about overmanaging employees on leave. So those are 3 takeaways from the Quebec perspective.
Have a wonderful day, and thanks very much.